In the annals of American political history, few battles ignite a firestorm quite like the clash between state and federal power. Today, the nation watches with bated breath as California Governor Gavin Newsom launches a direct assault on presidential authority, petitioning the highest court in the land to rein in what he perceives as an overreach of executive might. The stage is set for a monumental showdown. Newsom versus Trump, not on the campaign trail, but within the hallowed halls of the Supreme Court. The core of this unprecedented legal challenge? The president's controversial and assertive use of federal military forces within American cities, a move that has sparked outrage, constitutional debate, and profound sense of unease across the political spectrum. This isn't just a legal maneuver. It's a battle for the very soul of American governance and the balance of power that underpins its democracy. The genesis of a constitutional clash, the simmering tensions that led to Governor Newsom's dramatic legal challenge did not erupt overnight. They are the culmination of months, if not years, of escalating friction between the federal government and various state administrations, particularly those led by Democratic governors. The flashpoint, however, coalesced around the federal deployment of active-duty military and paramilitary forces, including those from agencies like the Department of Homeland Security, into American cities. Ostensibly, these deployments were aimed at quelling civil unrest and protecting federal property amidst widespread protests. Yet critics, including Governor Newsom, argue that these actions often went beyond their stated purpose, leading to instances of perceived heavy-handedness, violations of civil liberties, and an alarming disregard for the authority of local and state governments. The images of unidentified federal agents detaining protesters, often without clear legal justification in the eyes of state officials, serve as a potent catalyst, transforming political disagreement into a full-blown constitutional crisis. This perception of federal forces acting autonomously, often without the explicit request or even against the will of local authorities, directly challenged a long-established principle of federalism, where states retain significant sovereign powers. Newsom's bold legal gambit. A direct appeal to the Supreme Court. Governor Newsom's decision to bypass lower courts and petition the Supreme Court directly signals the perceived urgency and gravity of the situation. This isn't a typical lawsuit. It's an extraordinary measure reserved for disputes between states or cases of significant national importance that warrant immediate high court review. Newsom's legal team is reportedly building an argument on several key pillars. Firstly, they contend that the president's unilateral deployment of federal military personnel into cities, particularly when not requested by state governors and without a clear declaration of a national emergency or insurrection, infringes upon the 10th Amendment. This amendment reserves powers not delegated to the federal government to the states or the people. The argument posits that maintaining public order within a state's borders is fundamentally a state responsibility, primarily handled by state and local law enforcement, including the National Guard when activated by the governor. The federalization of these forces, without gubernatorial consent, is viewed as a direct usurpation of state sovereignty. Why? The Posse Comitatus Act. A cornerstone of the argument, a central plank of Newsom's legal strategy undoubtedly revolves around the Posse Comitatus Act. Enacted in 1878, this federal law largely restricts the use of the U.S. Army and Air Force from performing domestic law enforcement duties. While there are exceptions, such as when authorized by Congress or in cases of declared national emergency, Newsom's challenge likely argues that Trump deployments fell outside these narrow parameters. The act's intent was to prevent the military from being used as a police force against American citizens, a principle deeply rooted in the nation's fear of a standing army being turned against its own populace. The perception that federal agents, some with military-like training and equipment, were operating without clear civilian oversight or accountability within city limits directly confronts the spirit, if not the letter, of this foundational law. The debate will inevitably delve into whether the deployed personnel technically constitute military under the Act's definitions, particularly when agents from non-military federal agencies like Homeland Security are involved. Ed. Federal authority versus state sovereignty. A timeless American debate, the Supreme Court showdown, is not merely about specific deployments. It represents a reignition of a timeless American constitutional debate, the delicate balance between federal authority and state sovereignty. Throughout U.S. history, this tension has manifested in various forms, From nullification crises to civil rights struggles, the Trump administration's stance has consistently emphasized a robust interpretation of executive power, particularly in matters of national security and maintaining public order. Proponents of the president's actions argue that when local authorities are overwhelmed or perceived to be ineffective in controlling unrest that impacts federal property or interstate commerce, the president has an inherent duty and authority to intervene to uphold federal law and protect federal assets. They might cite the Insurrection Act as a potential justification, which allows the president to deploy military forces to suppress civil disorder under specific circumstances. However, Newsom's challenge aims to draw a clear line in the sand, asserting that such interventions must respect state autonomy and the constitutional limitations imposed on federal power. The precedent-setting implications of the High Court's decision, the Supreme Court's decision in this case, should it choose to hear it, will have far-reaching implications, setting a significant precedent for the future use of federal military and paramilitary forces within American cities. A ruling in favor of Governor Newsom could severely curtail presidential power to deploy such forces unilaterally, strengthening the hand of state governors in managing domestic unrest and reaffirming the principles of federalism. Conversely, a ruling that upholds the president's actions could significantly expand executive authority, potentially opening the door for more frequent and broader federal interventions in state affairs, even over the objections of local leaders. This isn't just about the immediate political climate. It's about defining parameters of presidential power, the rights of states, and the liberties of citizens for generations to come. The decision will undoubtedly reshape the interpretation of the Posse Comitatus Act and the Insurrection Act, clarifying when and how the federal government can bring its formidable resources to bear on domestic soil. A nation divided. The broader political and social context beyond the intricate legal arguments. This showdown is steeped in the broader political and social divisions that characterize contemporary America. For many, Governor Newsom's challenge is a necessary defense against authoritarian tendencies and an overreach of federal power that threatens democratic norms. They see the deployments as an escalation of force, infringing on the rights to peaceful assembly and free speech. For others, the president's actions are viewed as a necessary step to restore law and order in cities perceived to be spiraling into chaos, and a rightful exercise of executive power to protect federal interests. The legal battle is therefore not just a technical dispute. It's a proxy for deeper ideological conflicts over the role of government, the balance of power, and the interpretation of constitutional rights in times of crisis. The Supreme Court, often seen as the ultimate arbiter of these profound questions, is once again thrust into the spotlight, tasked with navigating a highly charged political landscape with constitutional clarity. The outcome will resonate far beyond the immediate parties involved, shaping the future relationship between Washington and the states, and perhaps the very nature of American democracy itself. What happens next? The road ahead for this landmark case now. What happens next in this high-stakes legal drama? Governor Newsom's petition will first be reviewed by the Supreme Court justices to determine if they will grant what is known as a writ of certiorari, essentially agreeing to hear the case. Given the extraordinary nature of a direct appeal and the profound constitutional questions at stake, there is a strong possibility the court will take it up. If they do, both sides will submit extensive legal briefs, presenting their arguments in detail. Then, oral arguments will be held, where attorneys for California and the federal government will present their cases directly to the 9 justices, fielding their questions and rebuttals. The Supreme Court's deliberative process is often lengthy, and a final decision could take months. Regardless of the outcome, this supreme showdown ensures that the debate over federal power, state sovereignty, and the use of military forces on American streets will be etched into the nation's legal and political consciousness for years to come. The weight of history and the future of constitutional governance rests heavily on the deliberations of the nation's highest court.